In this slide, I've tried to prepare a chart which compares an estate plan that revolves around a revocable living trust with an estate plan that does not have a revocable living trust. I've divided the features into lifetime needs and needs for the disposition of property after your death. When you look at the chart, you'll see under the heading Lifetime Needs that the first thing listed is financial management for yourself. The issue is, if you become incapable, how is the management of your property going to be dealt with? Because a revocable living trust is an agreement and has provisions in it that deal with lifetime issues, it can provide for the financial management of your property if you become incapable. If you don't have a living trust, the alternative is a power of attorney. Compared to a revocable living trust, a power of attorney is a relatively simple form. When you sign a power of attorney, you are appointing somebody to be your attorney in fact. That's kind of a fancy way of saying that you're appointing an agent. When you prepare a power of attorney, you are appointing an agent and giving that person a lot of authority to deal with your assets. That person is considered a fiduciary, which means he owes you a duty to use that power not for himself, not for the agent's benefit, but for your benefit. One disadvantage of a power of attorney is that if the person you name as your agent dies or becomes incapable, the power of attorney becomes ineffective. With a revocable living trust, however, if the person you name as your trustee dies or becomes incapable, the trust does not become ineffective. In that case, it would be necessary to appoint a successor trustee. Usually, the revocable trust agreement will include provisions that name successor trustees, so if one trustee cannot serve for some reason, another trustee will be identified, or there's a procedure in the terms of the trust that describe how a successor trustee is to be appointed. That is one reason why revocable living trusts are generally thought of as a superior way to deal with the management of your assets during your lifetime, because it's a more permanent solution. On the other hand, powers of attorney are not as permanent. Also, with a power of attorney, you can't be certain that the agent will be able to make a transaction happen. The reality is that bankers and brokers have seen too many transactions where powers of attorney have been abused, and they've become more and more reluctant to honor them. So if your agent attempts to withdraw money from your bank account under the authority of a power of attorney, the banker may be reluctant and resist, especially if the power of attorney is old or looks different, or if you and the agent are complete strangers to the banker. Legislation has been enacted to try to impose a duty on third parties, like bankers and brokers, to honor a power of attorney, but such legislation is not perfect, and you still can't be certain that the agent you appoint under the power of attorney is actually going to be able to make a transaction happen quickly and without a hassle. That's usually not true with a revocable living trust. When you have a revocable living trust and the assets are in the trust, in other words, the trustee is the legal title owner and is in possession of the trust assets, as far as everybody is concerned, the trustee owns the property. The trustee's power is not a delegated power. The trustee's power is as the owner, and the trustee's power is derived from the terms of the trust agreement. As the owner with the power granted in the trust agreement, the trustee is the only one who can deal with others regarding the trust property. Others who deal with the trustee can take comfort in the knowledge that they are dealing with the only one, who's the owner, who has authority to deal with the trust property. If you establish a revocable living trust, when it comes to the management of the revocable trust assets while you're alive, keep in mind that the revocable living trust is effective when the agreement is effective. That's when you sign it and deliver assets to the trustee. Because it's effective while you're alive, the terms of the trust can provide for all sorts of things while you're alive. One of the things it can provide for is that if you become incapable, your assets can be used for the support of others. So there can be extensive provisions in the revocable living trust agreement to deal with that possibility. If you don't have a revocable living trust, The question is, if you become incapable, is it going to be possible for your assets to be used for other people? Generally, the answer is not as well. You can provide the agent under your power of attorney with the authority to make transfers of your assets to other people, in other words, the authority to make gifts, but you can't do it as well as you can in the revocable living trust. Because the agent under a power of attorney is supposed to exercise his power for your benefit as your fiduciary, not for the benefit of others, the agent under your power of attorney might be a little bit reluctant to use your assets for others unless the agent has express authority to do so. The agent should be comfortable using your assets to satisfy a legal obligation of support that you may owe to a spouse or a child, but without an express grant to do more, the agent under the power of attorney probably would not be authorized to use your assets beyond that. Let's talk a little bit about what happens after the grantor's death when a revocable living trust is likely to be the grantor's primary dispositive document. In that case, the revocable living trust is the center of the estate plan instead of the will, which probably would be the center of the estate plan if there were no revocable living trust. What happens if you don't have a revocable living trust? Earlier, we talked about how, if you don't have a revocable living trust, it's necessary for your executor to go down to the probate court and ask the court to admit your will to probate. So your executor must go through an application process. In routine situations, there's nothing troublesome or burdensome about the probate application process. In routine situations, it usually goes smoothly without any problems, although there can be some delay before the will is actually admitted to probate and the executor is appointed. If you have a revocable living trust, and if you've done a good job of transferring all your assets to the revocable living trust so that at your death there are no probate assets, then there may be no reason to probate the will. That also would mean that there's no reason to have an executor appointed. If you have a revocable living trust, keep in mind you've already transferred all the assets to the trust, so the trustee already has possession of all the assets. There's no need for the trustee to go to the court to get a blessing from the court that says that the trustee has authority to take possession of the trust assets, because the trustee already has possession of the trust assets. In the next segment, we'll continue the comparison that we started in this one.